Anyone used Napster before? No? Okay, so we will analyze it anyway. So Napster, we know that is a platform for people to share the songs, right? So basically, Napster gets sued by Sony for violating the intellectual properties, meaning that it allows its users to share the songs. So let's look a little bit into the business model to see what Napster did, and we will see whether or not Napster violated the laws. So Sony sued Napster for, as I mentioned, for allowing the users to share the songs, more precisely the MP3 files. Napster arguments that it's the fair use. Remember about the fair use we talked about before, right? So Napster said that allowing their users to share the songs is a fair use. Why? Because it did not hurt the industry sales. They said that users sampled the music on Napster and bought the CD if they liked it. So they said that the quality of the MP3 files are not as high as the CD. And in fact, sharing the files is just for sampling the songs. So it's their argument, right? Okay. And also they said that Sony decision for creating the MP3 files or allowing the users to copy the song from the CD to MP3 files is considered fair use. Okay? So Sony allow the users to copy the CD for their own use, right? And then allowing to just creating the MP3. Okay. Okay, so it's Napster argument. All right. Furthermore, Napster say that it was the same as the search engine. Yeah, so their business model is as the same as the search engine, meaning that when the users log into their Napster web server, they will be able to search for the song they like and then will ask the other side to say, allow them to download that file. Okay, so we will go a little bit deeper into that, but right now, what they have is that it was the same as the search engine, which is protected under the DMCA. Okay, meaning the safe harbor provision. And Napster also said that they did not store any of the MP3 files. Okay, how can they do that? Because the users will have a list of songs they want to share. And then if I, for example, if I want to download a song, I will log into my Napster account and then I request that. Okay, so Mr. So-and-so, John Doe, can you share that song with me? And then they will allow me to download that. Okay, so that is what it means for the same as the search engine. Okay. All right, and then they say that they did not store any of the MP3 file. So, for example, if Mr. A requested to download a song from Mr. B, right? Then Napster did not store the MP3 files, but they will allow Mr. B to post it so I can download that. And after that, it will be removed, right? So they say that they did not store. It's just the other side allow me to download, I download, and then after that, it will be clear. So they do not store it. But they provide a platform so that people can actually share the files and download the file, okay, through their server. So their technologies has substantial legitimate uses. So it says that the technology for allowing people to share the songs have legitimate use. Okay? For example, besides sharing the song that is copyrighted, they also share the songs that has been released. Okay? For example, some songs that has no copyrighted issues at all, so they can share it. For example, the folk songs, for example, right? Or songs from the previous times, like 1950, 1940, for example. Okay? So they say that their technology has substantial legitimate use. Okay. And the Recording Industry Association of America, or the RIAA, said that no, it's not the case, right? So their arguments that it's not a fair use as follow. So number one, personal use, meaning that when they sell a CD to users, that CD is intended for a personal use. The personal means very limited use and not trading with thousands of strangers, like what they did on Napster, right? And songs and music are creative works, and users were copying the whole song, okay? Not a portion of the song, but the whole song, and thousands of them. And they also claim that Napster severely hurt the sales. Okay, so those are the arguments for and against the fair use of Napster case. All right, so we will talk about this to see how do you feel, okay? What would be your justification for whether or not Napster infringed the copyrighted songs. The second case we will also discuss about is the business model by Rockstar. Yeah. The case is a little bit different here. Rockstar is also a platform for music songs sharing. Yeah, but Rockstar is different with Napster before. Besides Rockstar, we also have GNU Teller, Morpheus, Kazaa, and other peer-to-peer file sharing services. Yeah. Now, remember that when we have Napster, when people transfer the files, the songs or MP3 files, they have to transmit the song through Napster's server. Okay? Even though Napster server did not store the songs, but they provided the platform that people can send the song to Napster server so the other side can download, and then after that, Napster will remove the record, right? But here, the P2P or peer-to-peer model is that the two persons, okay, so here's the platform, Rockstar, right? So person one will search the list of songs they want to download, right? So, for example, they ask, do you have the latest song from Taylor Swift, for example, right? Person two, uh, on the platform, on Webster, will say that I do have that, all right? But after that, they will not upload the file here, so P2, P1 can download, but there will be a direct connection from P1 to P2 that we call peer-to-peer connection. Okay, so peer-to-peer connection will allow these two users connect them directly. Okay, so for computer networking nowadays we have that protocol. So the P2P protocol will allow the two users to connect directly, and then they transfer the song from P2 to P1. Okay, so that said, Rotsu from MGM for the same reasons like the Napster. But here, Rockstar say that the companies did not provide a central service or list of songs. Okay? They do not provide the central service, as I mentioned, because they can ask, okay, whether or not you have that song. Okay? There's no list of songs available. Okay? They ask, and then they will connect directly. Okay, excuse me, I have to turn off the Chrome. Okay, and then the P2P file transfer programs have legitimate uses. Okay? So they say that they don't provide a central service. And then they also say that P2P file transfer have legitimate uses, of course, right? For example, nowadays when we have some connection, right? So instead of going through, say, the central server of some cell phones, okay, people can, after the handshake, okay, they can connect directly, so they can transfer. That will release the workload for the server. So that is one of the many legitimate uses of the P2P. Okay. So that is the second case. It's also about file sharing. Okay, so now after you hear about the arguments for and against Napster and Rockstar, okay, so it's about time to justify, okay, whether or not Napster infringe the intellectual properties, whether or not Rockstar violated the law, right? So pull out your cell phone, and then we will talk about the justification. Okay, so I will give you about 5 minutes. Okay, so I think we have enough for the quorum. So let's see what we have for the responses. So before we discuss about our solution, our responses, uh, let me remind you a little bit about the safe harbor, right? So the safe harbor is for protecting the host or the owner of the web service, or any online platform from charges when user post infringing materials, right? So in this case, obviously, the users infringe their, say, intellectual properties, namely their songs, right? But whether or not the host, like Napster and Grokster, uh, can be protected, okay? All right, so let's see what we have here. All right, so the question is, does Napster constitute copyright infringement? 36.8% say no, 36.8% say yes, maybe, and then 25% say yes. Okay, so we have a very diverse group here, right? Okay, let's see what we have for the justification. Okay, so the first one, even though it was made for MP3 file transfer, doesn't mean they specifically intended for copyright music to be shared. That's a user issue. Okay. So the second one is that they do not keep the files, so they only facilitate transfers. All right. So it's similar to the website, right? Okay. Similar to the website. And then also, we saw or we learned about the safe harbor provision. Okay? Napster isn't at fault for on the piracy, the people who illegally share music are, okay? Uh, and Napster isn't wrong because someone else used their technologies maliciously, okay? All right. All right. So now another opinion is that why they are not directly doing anything wrong, they sort of facilitating. Oops, yeah. Now the no is even more, right? Okay, 66%. Okay, all right. Okay, so this one, their service is allowing the users to send files to one another without being able to even check if the files are copyrighted. So I would imagine that they weren't looked at too favorably by the church. Yeah, so it's a good point. Yes, it's a good point. Okay, because they, without being able to even check if the files are copyrighted, it's a good point, right? I think this one is about roster. Okay. Oh, this one is about roster. All right. So for Napster, no is 38%. Okay. Okay. So here is another one. Yes, Napster constituted copyright infringement because it facilitated the unauthorized sharing. Right. Okay. Yeah. Good point. Right. So someone say that no, Napster did not violate uh, the IP laws, right? Because they are protected by the safe harbor provision of the law. Okay. Same thing for, and also, okay. This one is a good answer, right? Despite not storing the files itself, but they are still responsible for basically not checking whether or not it's a violation. Right? Oops. So now for the Grokster, so a majority of us say that no, Grokster did not violate the copyright law, right? Okay, 68.2% say no, and 22.7% say maybe, and 9.1% say yes. Okay, let's look at what we have for the justification. Same as before, it's a user issue. Okay. Rockstar never has the file because they are swapped peer-to-peer. All right. Same reason above, it's a service and not storing the file. Okay. And this one is interesting, right? So probably you copy the format as well. Okay. Rockstar, like its predecessor, facilitated copyright infringement by enabling users to share the copyrighted material without proper authorization. Yeah, it's a good point, right? Okay. Okay, so they did not store the audio file. They weren't reselling the music for sure. Sure, I mean, they did not resell the music, but of course, I mean, they earn money from other sources, right? For example, Napster or Grokster, they provide the free services, yeah, like Google, right? Google search engine is free, but of course they earn a lot of money from advertisement, for example, right? So basically, Google earn billion of dollars every year, okay? More than that, okay? More than 10 billion. Okay, all right, so interesting. We have a very diverse group. So let's see what we have from the court. The court ruled that sharing music via copied MP3 files violated the copyright. Okay, so sharing the music is a violation of the law. Let's see, but it's the violation of the law by the users. But how do they connect the case with the safe harbor? The court ruled that Napster liable because they had the right and the ability to supervise the system, including copyright infringing activities. So it means that, yeah, I mean, the users violated the IP law, but Napster, as the owner of the platform, they have the right and the ability to prevent that, and they did not do anything, okay, or they did not do enough, okay. So that is the court ruling, and you know that is the end of Napster. It went bankruptcy, right? Even though someone bought it and then bring it back, but using a totally different platform. They just bought the name of Napster. All right. So now, how about the Grokster and Casa and other platforms in that they use peer-to-peer? Yeah, this case is a little bit more complicated. the lower court ruled that P2P does have the legitimate uses, right? And then Grokster did not provide the platform for actually transfer the file, right? Nor they record the file. Okay. However, it went on the way to the Supreme Court, and the Supreme Court ruled that intellectual property owners could sue the company for encouraging the copyright infringement. Okay. Even though they and the users use P2P, but they still use the platform of Grokster in order to say query about, let's say, here is the song I want. Do you have it, right? So still, Grokster still have that responsibility, and the Supreme Court ruled that, yeah, they are encouraging the copyright infringement, and that is the end of the business. Grokster went bankruptcy after that, right? Because they have to terminate the platform. Okay? If they don't, then they will get sued and they will lose billions of dollars. Okay, so those are the two examples of the safe harbor. So in other words, the safe harbor protect, say, the owner of the website. However, the owner has the responsibility to, say, protect the IP, the intellectual properties. So that's why if they turn a blind eye against any kind of intellectual property violation, they will be in trouble, right? Because they have to do enough in order to be clear of any violations of the intellectual property laws. Okay, so, all right. Is it clear? So I think we have to learn about this situation because we are the programmers, software developers, right? So before we have our resources and efforts for building up a platform like Napster or Grokster, we have to review the impact of the new technologies on the society, especially the laws like this. Okay, so if we learn about this, or if a Grokster learn about this, then they should never spend hundreds of $millions for develop the platform like that, right? So it's a waste of money, waste of resources for building a business model, and at the end, went bankruptcy. Okay. All right. So I have many more discussion questions, but I think we have two for today. That is enough, right? So the next case I want to bring up here is about the look and feel. Yeah. All right. So let's have one example about that. Okay. So we know that Apple invented the way they have their icons for the apps on their iPhone, right? Also iPad and so iOS in general, right? And then when you want to move the icon, you can rearrange the icon, right? By clicking and then hold your finger and it will shaking. And after that, you can move or remove the icon, right? So we will try to have it again. after uh, Apple say filed for the protection, right? They said that it's their intellectual property. Okay, and same thing here for Google. They got sued from Apple. So we will discuss about this situation, right? It's important for us because we are software developers, right? Information technologists, right? So we want to design a software like Apple did here. So is it our intellectual property so it can be protected? So if someone else wants to use it, they have to pay for the intellectual properties we own, right? Okay, let's see what we have here. Okay, so look and feel refer to the features such that pull down menu, right? And then windows, icons, and finger movement, and specific way they are used to select or initiate uh, action. Okay, for example, double click, right? Or triple click, okay, or one click, okay, etc. So that those features are what we call look and feel. So we want to know whether or not that kind of features can be protected. All right. So let's see what we have here. All right. So pull out your cell phone again, and I want to hear from you about this situation. Okay, so when you answer, please be specific. Okay, what features of iPhone can Apple claim as their intellectual properties? Put down menu. Uh, is it? Uh, I mean, uh, is it something that Apple can claim? Windows, icons, finger movement, and specific way like checking of the icons, right? So, what features you have to list the features you believe that Apple can claim the intellectual property. Okay, so I think we have the quorum. So let's see what we have here. All right. Notification pane or panel, home button, swipe to unlock, lock button, okay, swipe to unlock. For example, uh, for iPhone, you swipe up, right? But does it mean that Google can have uh, swiping down and not violating, right? So it's just a question, right? Lock buttons, slide to power down, etc. Uh, Screen layout, color scheme, sound, general layout, and features of their smartphone. Sounds here. Uh, Nowadays, you can use a song, right? But for that reasons, do you think that uh, Apple can claim that the sounds from a song, for example, from Elton John, can be copyrighted by Apple, right? Yeah. General layout and features of their smartphone, OS, and anything else they feel they can claim is unique. Okay, it's unique. Okay, let's have one question about that. All right. So, for example, here, can Apple claim that they have the intellectual property for this icon, or this icon, or this icon, or this icon? The answer is no, right? Because TikTok owns this icon, and then Yelp owns this icon. So Apple cannot claim that I use this icon for Yelp, I use this icon for TikTok, and Google cannot do it, right? Because Google should have uh, the same Gmail, right? And then Chrome also. So when so they have Google Map, right? Google Map can be used on Google as well, Android as well, right? Okay, yeah. Apple can claim their own logos, icons, and software that they have developed. Yeah, that's a good one, right? So if it's their own logo, their own software, they can claim if they develop that, right? They do not have the right to prevent other software developers from utilizing certain features such as drop-down menus. Drop-down menu is uh, not new, right? So we have it from, say, 1990s, right? So at that time, when we have the operating system, or we have, for example, Microsoft Office, we already have the drop-down menu, okay? Okay, this one is, maybe next time you need to be more specific, right? None, uh, actually, Apple can claim a lot of things. Like I said before, uh, the icons, when you click and hold, it will wiggle, right? Allow the users to rearrange the icon. Yes, Google has the pattern for that, and it means that it's their intellectual property. Okay, all right. Yes, so very good. A lot of things. Okay, again, series, right? So it's their copyrighted intellectual property. Okay, so again here, I don't think any of it. So I mean, you have to look back because there are many things they already claim of intellectual property. Okay, so we have the first question is about what features, right? And then the reasons for your justification. Okay, so the reason. So iPhone uniquely used this before other smartphone manufacturer. Okay, so they use it. Actually, they invented some of the features and they use it in advance. And they already find the patents. So some of them they have the copyright protection. Yeah, other companies cannot make things that look and sound identical. Yeah, that's a good reasons, right? Because you cannot have a copycat. And they spend a lot of time and efforts in order to have their user interface, and someone can simply copy that. Is not fair, right? Okay, so we have many good justification here. Yeah, I also like this one. Okay. Look and feel is such a vague phrase that it can be used by the company to restrict any app development of other competitors, right? So in fact, it's very true for Apple. Sometimes they overclaim what they did, and that prevent the uh, the new work of software developers, right? So Google, Apple is and has that known problem. Sometimes they overclaim, and that prevent the other companies for the new invention. That's very true. Okay. All right. So very good. So here is one feature that went all the way to the court, right? And Apple win the patent for iOS app folders and jiggle mode. Okay, so they have the app folder where you can add, say, a lot of apps into that folder. And then they have the way for, and they say the icons will shake a little bit, or they call it jiggle a little bit, right? And after that, you can move to rearrange, or you can delete the icon. And Apple win the patent when, uh, say, Google try to copycat that for the Android operating system. Okay, so that's it. I think it's a lesson for us, right? So when we join a company or when we want to develop our own application, then we have to be able to recognize that whether or not copycat is something we should do, right? Because we spend a lot of times and efforts in developing a new software, and at the end got sued and we lost hundreds of millions of dollars. That is something we don't want to do, right? Okay, so some of the ideas we want to hear about, I mean, for the last few slides is that we want to see what kind of responses is appropriate for copyright infringement. So we need to have the responses from the content industries. For example, Apple or Google, and they have their contents. So if something violated, right, we want to hear from them. Or they have to initiate the process saying that that company violated our intellectual property, right? And then we have to ask them, stop doing that. Otherwise, we will bring you to the court and you will have to pay on the penalties, right? Okay. Also, some of the ideas we have here from the software industries. On the one hand, we want to protect the intellectual of some works, right? Like what Apple did. On the other hand, we also want to have some ways to promote the innovation, right? So that's why sometimes we want to have the expiration date within the software. Okay, for example, Microsoft, they have the Microsoft Word, right? So they make a lot of money from that. But now maybe we need to have the new ideas about having another software that can help people to prepare the documents. Okay, for example, using the open AI or the new large model language we have nowadays. So that said, is it a good idea that every time when we have a software that is copyrighted, should we have, say, the expiration date? It's not a new idea, actually. When you look at the pharmaceutical companies, they have the new drug, right? But every new drug will have an expiration date. You have the protection for 15 years, or you have a protection for 25 years if it's a very special product, right? So maybe we can copy that idea here. A software or an application may have an expiration date, and after that, it will become free, right? So everybody can use it for free. Everybody can, let's say, have a copycat for that. Okay. So like drugs, so after 15 years, they can have, say, the generic drug for exactly the same features, right? And of course, the cost will be 1/10 of the original price. So that is also a good idea, right? Or in order to protect the intellectual property, maybe we can talk about the dongle. The dongle means a device that must be plugged in the computer in order to run an application. Okay, so sometimes we also say that, I mean, we want to discuss whether or not it's a good idea to prevent or to protect the intellectual property. Or activation code. So this one is used a lot nowadays, right? You buy a software, but you can only use it after you activate that. So when you activate, then you tie the MAC address of your computer to that license. So it means that they have the record of who is using that copy, right? All right. Copy protection also, right? For example, to have some kind of protection that prevent people from copying the CD or the DVD. Also, we may want to have the court orders that can shut down the internet bulletin board or the website. So, for example, if we know that a specific website is, posting some intellectual properties that we own, then we can ask that website to stop doing that. Otherwise, we can ask the court to order them to shut down, and of course have to pay the penalties. All right. Of course, we are living in the a very advanced world in that technologies are used very often or very crucially. However, some countries do not recognize or protect the intellectual property. So that is an issue, right? Or some countries that have the high piracy rates. So that said, doing business in those countries is an issue for some of our businesses here. All right. So in conclusion, the DMCA Act has two provisions, right? So the first one is anti-circumvention that we learned before. And the second one is safe harbor we learned today. So even though this safe harbor provision protect the website from lawsuits for copyright infringement by users, but the websites have to do enough in order to prevent the infringement by the users. So they have to be able to detect if an infringement happened, and if yes, they have to take actions to remove those infringement from their website. So if it's the case, then they can protect it, right? Otherwise, if they turn a blind eye away in order to attract new users so they can collect the advertisement cost, then they will go through. Okay, so that said, when we look at this provision, we have to be able to analyze the situation to see whether or not that provision can be applied. Okay, like Napster or Rockstar, they are not protected under this safe harbor. Okay. All right. So also here is another thing we have to keep in mind, right? So when we learn about copyright infringement, we also have to look at other things that is related to the infringement. For example, we have to be able to justify whether or not a use of the intellectual property is a fair use. Okay? We already learned the 4 factors of fair use at the beginning of the chapter, right? The second thing, we have to connect between intellectual property protection and freedom of speech. Okay? So sometimes it's important to protect the intellectual property, but we also have to be sure that the freedom of speech is respected. Okay, so here's one example. The US court have banned the technologies such as the DECSS is for content scrambling service. Okay, so remember that the DMCA, the first provision is the anti-circumvention provision, right? And the DECSS is the software that will circumvent the content scrambling service. So under that anti-circumvention provision of the DMCA law, we cannot have the DECSS, right? But the question here is that what will happen if I have my software, I have an algorithm that can, let's say, remove or at least nullify the content scrambling service. Yeah, so I have an algorithm, right? And then I wrote a program for that purpose. So can I just post the program on the web? Yes. Remember what we have before about the algorithm for, say, encryption, right? So Professor Bernstein from the University of Illinois at Chicago, right? So when we learn about freedom of speech, okay, he sued the Department of State that he was not allowed to sell that product, okay, or he was not allowed to post the program for that purpose. And the court ruled already that it's the freedom of speech because his program is a written statement using the programming language, right? So a programming language is a language. So therefore, the program he wrote is a statement, right? And that is protected under the law, okay, for freedom of speech. Okay, so the same thing here. There was a person who posted that program for the CSS, and then the a court in California said that, they can get sued for the anti-circumvention provisions of the DMCA law. Okay, so, but we know that we already have the freedom of speech case before, and that said, when they got sued, that person is from Texas. Okay? He posted that, and the Hollywood sued him for posting that one, right? But that was, it went all the way to the Supreme Court of the state of California. And because we already have a previous case relating to a very similar situation in that we have the freedom of speech, right? So simply they reject that by simply saying that he cannot go sue in California because he lives in Texas. But it's the end of the case, right? So, however, even though we can post the program for that, right? But okay, so I think I have one slide here saying something about that. Okay, so hold on, one more slide. Okay, so let me. Okay. All right. So even though we can post the program for the DE or DCSS, right? But the law prevent any companies from producing a device like DVD player that has this software incorporated. Okay? Or in other words, they, for example, we don't have any device, right, that can say for the video, right? So we cannot have any device that will have this DECSS program implemented or installed on the device. It's still something that people cannot do for copyright protection. Okay, it's understandable, but posting the contents is allowed under the freedom of speech. Okay, so that said, when we talk about the safe harbor, we also have to pay attention to what we call takedown notices, okay, for the DMCA laws, right? As long as the sites like YouTube or MySpace comply with the takedown notices, they are not in the violation. Okay, so even though they are not responsible for the violation of the users, but they still have to detect the infringement and take down those violations, right? And if they do that, then they will not be responsible for the user's violation. Otherwise, they will, like Napster or Grokster. Okay. Okay, we already talked about this. Okay, so here is another example, right? The point of this example is that we have the DMCA laws, right? And we have many other laws to protect the intellectual property. But as I mentioned before, we have the innovation moving much faster than the laws. So let's see, sometimes we have the situation that is not addressed in any law, like this one. Okay. Zidiva, a small startup in 2011, they bought the DVDs, okay, and they rented the content, not the physical DVD, to customers legally. So that's it. Yeah, they bought the DVD and then they rented the content. Previously, we have some, let's say, businesses that they bought a DVD and then they rented the DVD to customers, right? But here, this guy has a new model. They bought the DVD, but then they make the files, the copies, right? And then they rented the contents, not the DVD itself, all right? So that is, I mean, people will have many, many new ideas about making money, right? So this one is one of those. So he thinks that he can earn a lot of money, right? But the court ordered the diva to shut that, okay? Because the court said that is a violation or is an infringement of the copyrighted materials, right? So that's it. Before they have the business, they need to understand or they need to review their situations, right? To see whether or not buying the DVDs, make many copies as their, I mean, streaming files and share that. Okay? Is it legal? So it turns out that it's not legal. So that is the end of the business. Okay, so I think that is all things I want to mention for the intellectual properties. Okay. Any question you have? I will post the case study sometimes today, right? So as usual, we will have an assignment in that you review one case study for each chapter, right? So I will post it today. So you can review the case study for this chapter and then wait for the next one and finish the essay. It's up to you. You can do it one by one or you can do it